Mr. Galt, if you can have a seat there, please. We'll go on the record. This is People versus Richard Galt, file number 244943. The record should reflect Mr. Galt's presence here in the courtroom today, so I can have counsel put your appearances on.
Ryan Ziegler on behalf of people.
Thank you, Honorable Gurmurthy, on behalf of Mr. Galt.
We're here today. Mr. Gurmurthy has filed a motion to withdraw as Mr. Galt's attorney. I guess one thing, it affects the court's consideration here. I want to make sure the record is clear. Again, because I think there's a difference between Mr. Galt, you asking the court to appoint a different attorney for you, and Mr. Gurmurthy asking to withdraw from the case. So I want to make sure that we're clear on the record which of those two I'm dealing with.
Well, I'm going to ask that I withdraw from the matter. I think the other issue, which, and I'll leave it to the court's discretion. Mr. Galt is requesting another counsel. There's a process to that because the court no longer appoints counsel. Mr. Galt has been made aware of that. Mr. Galt has been made aware of that by Mr. Thompson, who is the indigent defense counsel.
Actually, before we go further, Mr. Thompson is, let me bring him in.
Okay, right. And I was just going to say Mr. Thompson wanted to attend this hearing as well.
Your Honor, I've filed several motions
Okay.
to the courts.
Okay, and we'll talk about that in just a second. Mr. Thompson, are you able to hear me okay?
I can hear you, thank you.
All right, we just got started with the hearing involving Mr. Galt. I asked for a clarification as to whether or not Mr. Galt was asking for different appointed counsel or whether Mr. Gurmurthy was asking to withdraw from the case, because those are two different considerations, or whether it's both. And so we've just begun that discussion just to bring you up to speed here. So Mr. Gurmurthy, you're asking to be withdrawn. Mr. Galt, are you asking for a different appointed counsel as well?
Yeah, well, Your Honor, first time I filed a motion, I was assigned, and this was back in July of 2024. I was assigned a new attorney because Mr. Gurmurthy was never actually. See, what happened is Mr. Seeger assigned himself to my case with a direct conflict of interest. You know, he represented the victim in the case, the victim's boyfriend, the victim's sister, the victim's sister's boyfriend, both of the victim's children. And it took me 5 months, 150 days, before Mr. Seeger was willing to withdraw and acknowledge the conflict issue. So then, since there was a conflict issue, he handed me off to Mr. Thompson. Well, in the process, I got this letter here from Mr. Seeger. Says, I have enclosed a substitution of counsel. If you wish to have alternate counsel, this is your opportunity. And then again on this page, second page, I have enclosed a substitution of counsel. You may execute this form if you no longer wish me to be an attorney. You may. So this was with Michael Horwitz. I said, well, Mr. Seeger, Michael Horwitz, you share an office, so it's still a conflict issue. So he goes, okay, I'll see what I can do. He goes, you have anybody else that you would be interested in? I'm like, well, I talked to Patrick Cherry. He said he'd take the case if you'll appoint him. Mr. Seeger talked to Patrick Cherry. Patrick Cherry said that he wanted $350 an hour. So Mr. Seeger said, well, we ain't paying that. Okay, whatever. So he comes to me and he's like, I talked to Mr. Gurmurthy. He said he'd be willing to take your case. He goes, I'll send you substitution of counsel paperwork, and you can sign and return to my office, and we'll get Mr. Gurmurthy appointed to your case. So he sent me the substitution of counsel paperwork, which I have a copy of here. I got the original back at the cell. I never got a chance to sign it. It's never been signed to send it to me. It's never been ordered by a judge that Mr. Gurmurthy was even appointed to me as counsel. Okay, so I'm like, you know what? I'm not going to say nothing, because if things go bad, I can always be like, Mr. Gurmurthy was never actually legally appointed to my case. So that's automatic grounds for an appeal right there. So I didn't say nothing.
All right, guys, buckle up, because this case doesn't warm up slowly, it kicks the door in. In just a few seconds, the narrator frames what we're about to watch: a defendant who believes the system owes him something, and a courtroom that's clearly had enough. This intro isn't about facts yet, it's about tone. You're being told up front that this hearing won't be calm, respectful, or predictable. It's the calm before a very loud storm, and the audience already knows someone is about to talk themselves into serious trouble.
Well, then Mr. Guramuthi refused to call any witnesses that I wanted him to call at the preliminary exam. So that's when I was like, you know what? Heck with this, I'm filing a motion to withdraw, or filing a motion for substitution of attorney. So I filed a motion through Mr. Thompson because the case had to get handed to Crawford County because of the conflict issue out of Kalkaska. So I filed a motion and I was appointed a new attorney. Right here, for my August 1st, 6th court date is Shauna Sullivan. Right here, she's an insurance fraud investigative attorney out of Braintree, Massachusetts, that is allowed to practice law in Michigan. So I contact her and she's like, Mr. Galt, I'm not a criminal defense attorney. I'll contact the courts and get this straightened out. So she contacted the courts and I get a second notice for the same court date that says, this hearing will be held via Zoom. Defendant is lodged, notice resent with no change other than defendant's attorney is now Guramuthi. So I got appointed a new attorney and reassigned Mr. Guramuthi. So then we go to the court date on August 6th, Your Honor, Zoom, and I'm in Wexford Jail. And you're like, okay, Mr. Guramuthi, how's 90 days sound for continuance to file motions? And Mr. Guramuthi says, your judge, how about 120 days? And you were like, will that be enough time? And he's like, absolutely. So then on December 3rd, 14 months after I was arrested, no motion's been filed. I'm going to use your exact words, Your Honor. Mr. Guramuthi, you didn't show up today to court. That is unacceptable. Mr. Guramuthi, you didn't file your motions today. That is unacceptable. That's unacceptable. That's ineffective assistance of counsel. 14 months later, that one motion's been filed on my behalf, and you granted him 120 days to file motions. I've never even got a copy of the motions that were filed. He gave me a rough draft of these motions that had my case and Joe Cunningham's case mixed together. He came to the jail 2 days before court, the court date where the motions were filed on time, to do the corrections. He's like, I'll get you the corrected copies that I'm going to file with courts. I've still never seen a copy of the motions that were filed. I don't know what copies of motions were filed. So then I asked for transcripts, because I wanted transcripts, where you, Your Honor, stated, Mr. Guramuthi, you not showing up today is unacceptable. You not filing motions on time is unacceptable. I want them transcripts where you, Your Honor, said that, in case it comes to an appeal purpose. And then when we come to the motion hearing on January 24th, you're like, well, I'm not going to have you and Mr. Guramuthi both arguing motions. I said, all right, well, I'll let Mr. Guramuthi argue motions. So you're like, Mr. Guramuthi, do you have anything to say about arguing these motions? Mr. Guramuthi's like, no, Your Honor, I'm good. Well, if I'd have known he wasn't going to argue them, I would have argued them, Your Honor. You know what I'm saying? So there's another ineffective assistance of counsel.
All right, guys, now the courtroom officially goes on record, and things get real fast. What should be a routine procedural moment instantly turns tense when defense counsel signals a desire to withdraw. That single move changes everything. The judge immediately locks in, clarifying whether this is a lawyer problem or a defendant problem. Spoiler alert, it's both. This moment quietly sets the chessboard for the entire hearing, because once withdrawal is mentioned, the court has to decide whether justice moves forward or gets dragged into delay hell.
I've begged Guramuthi to file several motions, and I've got a list of the motions here. I even researched case laws for him for his motions. And he refuses to file motions. He refuses to He refuses to request body cam footage of the search in its entirety. I want officer activity logs. I've got proof with me today of Detective Nichols perjuring himself on the stand under oath. I've got right here.
Well, let's try to stay on the lawyer issue, because that's.
Well, this is a lawyer issue. This is stuff I'm pursuing.
Well, I'm not going to make any decisions about what police officers did or didn't testify to today. So tell me how that relates to your attorney issue.
Because I've asked Mr. Guramuthi to address this with Mr. Ziegler and be like, look, we could discredit your witnesses. We can work some kind of a deal, something. You know, I got, my deal from Mr. Ziegler, Your Honor, was on 86 district paperwork with the wrong case number on it from the prosecutor. That was his deal. Another thing is I asked Mr. Gruber to file a motion, is you know what, Your Honor, felony complaints, citations, anything signed in those are made under oath, sworn to. You gotta be sworn to. I got a felony complaint right here with the paperwork filed from the prosecutor, signed with the complaining witness that says I committed second-degree homicide on 10/30/2023 in Cold Springs Township. That's 2 days after the defendant was dead. I got a felony complaint right here that says the complaining witness has filed a sworn complaint in this court stating that on a date and location described above, contrary to the law, Mr. Galt in Cold Springs Township committed second-degree homicide on 10/30/23, 2 days after the defendant was dead. I've asked Mr. Guramusi to file motions to quash charges due to the fact that I was illegally arrested, illegally arraigned on a felony complaint and a felony warrant that contains false information. It was never signed and dated by anybody, the return and tabulation, where I was arrested. I've requested the SIDNET reports, which is an electronic report record for arrest, to find out who even served the arrest record, because I've never seen a felony warrant for 17 months. And I knew that the felony warrant was based off a felony complaint, which was inaccurate, but I couldn't do nothing without the actual felony warrant showing that I was illegally arraigned, illegally detained, and illegally arrested based on a complaint and a warrant with false information on it. Okay, this is where it gets good, Your Honor, and I brought this all to Mr. Guramuti's attention. The uniform law citation that was filed to go with the complaint, right here, case number, says nothing about second-degree homicide. In fact, the one that says second-degree homicide was filed on 11/4, 6 days after the defendant was dead, 4 days after I was arraigned, by Sloan Kowalewski, stating that I committed second-degree homicide on 10/27 at 12:00 p.m.
All right, guys, this is where the defendant hands the court a loaded weapon and then complains when it fires. He launches into a long explanation about conflicts, substitutions, and paperwork, but buried inside the rant is a jaw-dropping admission. He openly says he stayed quiet on purpose so he could use it later on appeal. That's not confusion, that's strategy. And judges absolutely hate strategy that smells like manipulation. From this moment on, the court isn't just listening, it's evaluating intent, and that's a dangerous shift for any defendant.
It also says that I was arrested on a warrant on 10/30/2023. Warrants were issued until 11/1. That's false. That's lies in the uniform law citation. Now, this is where it gets good, Your Honor. It says right here, do not write.
I'm not gonna, this isn't I'm not making any decisions on that. I'm not gonna dismiss your case today.
I'm not saying you are, but I need this
You're
all on
going into
record.
argument here on underlying issues. We're just dealing with the lawyer thing. So you think he should have filed motions on these things?
These are issues that I have brought to Mr. Guramuki's
Okay.
attention, and he's failed to file any motions that I've requested. And I want it on record that these are the issues that I've requested the motions to be filed on.
Okay.
You know, these are major issues, Your Honor. They are. This is a murder case. There should be no topographical errors. There should be no misprints. There should be no false statements in felony complaints. There should be no false statements in warrants. Returns and tabulations should all be filed.
Well, I don't know whether they're false or not. I don't know whether they're wrong or not. And I don't know whether that would make any difference. So, again, what we're here on today is the attorney.
So basically what
You're
I'm
asking for different.
basically, there's been a breakdown in attorney-client relationship. Mr. Guramuti has filed a motion to withdraw. I filed a motion for substitution of counsel based on, and this is just a few of them, just a few of the things.
Yeah.
You
Okay.
know?
All right. I understand what you're saying.
You know, just I don't know what to do, Your Honor. I'm looking at life in prison,
Well,
and I got a counsel that refuses to file motions.
well, here's the thing, okay, and I'm gonna talk to Mr. Thompson, but one of the concerns I have is it's not gonna matter what attorney I appoint to you, because you're gonna find something wrong with any attorney
No,
that's
I'm not.
appointed to you.
No, no.
Well, because you think that certain things have some significance, and if your lawyer tells you legally you don't have an argument here, or legally these are mistakes, but they don't affect the validity of the charges, you don't agree with that, and so you're gonna be back here again with your next lawyer who refuses to file motions that the lawyer thinks aren't warranted, and you're gonna be telling me the same thing. You understand what I'm saying?
Yeah,
Like,
but
you don't want to hear what your lawyer's saying because you disagree with it, and so you want me to keep appointing lawyers until you get one that agrees with you,
Well,
and that's not how this works. So that's my concern.
but don't, but.
When I listen to you talking, that's my concern is I could appoint 10 lawyers for you, and until one does what you want them to do, you're going to claim that they're not representing you effectively
See, this is the
because you're
thing.
not listening to what the lawyers are saying.
Mr. Garamusi doesn't even come and see me, Your Honor.
Okay, well, that's a different issue.
But this is the thing though, is the motions, Mr. Garamusi or whoever is appointed should be willing to file motions on these things.
Well, but that's
And
not
it's up to
true,
you to
though.
rule on them, Your Honor.
Lawyers don't just file everything that their client wants them to file. They have an obligation under the law to only file things that have legal merit. So
And
if you want him to file something, and in his judgment as an attorney, he doesn't think that it has legal merit, he or any other attorney that I appoint for you isn't going to file it. And what I'm hearing you tell me is that you want an attorney that's going to do everything that you want to do.
No.
That's not
No.
how it works. So that's my concern going forward with you and appointed counsel is that, again, I could go through attorney after attorney after attorney, and we never make it to trial because you can't find one that's going to argue things for you that no attorney thinks has legal merit. So I'm just saying that for the record, that's my concern here.
All right, guys, now we enter the familiar territory of ineffective assistance of counsel, a phrase defendants love and courts scrutinize hard. The accused claims motions weren't filed, hearings were mishandled, and his defense was ignored. But the judge isn't buying the emotional framing. Instead, the court calmly explains a reality most defendants refuse to accept: not every complaint equals a violation, and not every demand deserves a motion. This is the first time you can feel the judge pulling away from sympathy and leaning toward skepticism.
I do want to clear up some things that you said about the succession of attorneys and how we started and where we got. And Mr.
Just
Thompson,
could I
can you-
clarify before Mr.
Yes, Your Honor.
Thompson chimes in? Because I can just add a couple of things that Mr. Galt indicated. I think that's important for the record. So Mr. Seeger, I don't know the conversation Mr. Galt and Mr. Seeger had. But when I was.
Well, and I don't want to have you and Mr. Thompson, he's the administrator. I want to hear what Mr. Thompson says. I'll give you a chance,
Okay.
Mr. Gurmurthy.
Thank you.
But I want to hear what Mr. Thompson has to say is going to clear this up or shed some light. So Mr. Thompson, can you tell me what information you have as the administrator of MIDC here?
Yes, Mr. Seeger contacted me. He indicated he was recusing himself from administering this case as well as being an attorney. I appointed Mr. Garamuthi, the court clerk. We've called and confirmed this with the court clerk. Made a typo on the P number, and that's how a lady named Miss Sullivan was identified on a court filing. But Mr. Garamuthi was appointed as attorney. Mr. Galt did request a new attorney through me. I turned him down. At one point, he did appeal. We had that administratively sent to Mr. Slough, the Otsego County Administrator, who issued a written decision also declining to appoint new counsel.
Okay, all right, thank you, Mr. Gurmurthy.
And that is where I was just getting at, Judge. So I don't know the conversations Mr. Galt and Mr. Seeger had. Mr. Seeger reached out to me about this matter as conflict for Kalkaska County. In those conversations, and Mr. Seeger may have had those conversations with Mr. Thompson previously, or subsequently, I don't know. But one of the discussions was that since Mr. Seeger at the time was grieved by Mr. Galt, it made sense to not have Mr. Seeger on this case only administer the Kalkaska County MIDC administrative duties, and that should go to somebody else. And Mr. Thompson, being the Crawford County administrator, only took over on this case to administer this matter. Whatever request and funding or other things that we've had have gone through Mr. Thompson. At one point, I did reach out to Mr. Thompson with Mr. Galt's request for new counsel, because as Mr. Galt indicated, some of the motions that he wanted me to file, I think were frivolous. They weren't with what the law would require. And again, there was, when Mr. Galt indicates that a motion to quash was not filed, the court heard arguments that was filed. When Mr. Galt says that motions that he wanted were not filed, we did challenge the search warrant and filed motions to suppress evidence. Those were heard. We had arguments here in court. So I think Mr. Galt is incorrect that no motions were filed. The motions that he wants, that I don't believe legally would have any authority to be filed, were not filed because they're not there. For example, Mr. Galt wants me to file a motion to discredit Detective Nichols. I think that gets done at trial. There's no motion to discredit him prior to a trial. So again, the transcripts that Mr. Galt is requesting, he has those, because he has the preliminary exam transcripts. We had a full day, 8-hour preliminary exam in this court, and Mr. Galt was present. So again, some of the things that Mr. Galt indicates are not chronologically accurate.
All right, guys, this is where the argument completely derails into paperwork obsession. Dates, signatures, police reports, typos, everything becomes grounds for appeal in the defendant's mind. But the courtroom reality check is brutal. The judge makes it clear that criminal cases aren't dismissed because of clerical imperfections. This segment matters because it shows the growing gap between legal reality and the defendant's self-taught legal theory. The more he talks, the clearer it becomes that he's arguing process instead of substance, and that rarely ends well.
I did not know that there was that appeal process that went to Mr. Slough. I know Mr. Slough at some point did get involved because I received a subsequent letter from Mr. Slough because Mr. Galt had indicated that he wanted new counsel. I didn't know how Mr. Slough got involved, but I spoke with Mr. Slough and I indicated where my concerns were. But my breakdown comes in after all of those things were done, because certainly Mr. Galt didn't get what he wanted. He didn't get a new counsel. He was turned down by 2 administrators. And I haven't met Mr. Galt in the last 2 weeks, maybe 3 weeks, because I'm not going to take his verbal abuse. I'm not going to sit there and get called derogatory names. I'm not going to deal with his threats. And if I'm going to spend my time meeting with him, it's got to be a productive meeting, not one where I get yelled at, screamed at, called names, and threats being made.
Your Honor.
So at this point,
Second, I'll give you a chance. It's his turn.
I'm
I
sorry.
listen to you. Go ahead.
so when those things happen, I'm not going to waste time and get treated that way. I'm not going to subject myself to that. Mr. Galt is, and I've told this to him, he's not my friend, he's not a family member, he's not a relative, and I'm under no obligation to take his verbal abuse because he doesn't get things done the way he wants or wants, new counsel, whatever his beef is. At one point, he was upset regarding something that happened with his house in landlord-tenant court. Again, there's a limit for me being a punching bag. I've got to deal with this case. This is where I am. But when it gets over that line, I'm not going to deal with Mr. Galt's abuse that way. I'm not going to subject myself to that. I have some self-worth, and I'm going to hold myself to that. I've told Mr. Galt that, and Mr. Galt doesn't like that because I stand up to it. Leaving all of those things aside, Mr. Galt has filed a grievance. Mr. Galt has, my understanding, filed a grievance against Mr. Slough and Mr. Thompson.
Never filed one on Mr. Slough.
Mr. Galt indicated he's filed a grievance against Mr. Ziegler. So in the middle of a murder trial and prepping, I have to deal with grievances that have strict time constraints and requirements and turning over documents and other things that come with the own separate proceedings that I believe are frivolous, but I have to deal with those. And I've just reached a point where I've had a breakdown with Mr. Galt, and then I can't do my duty. My loyalty to Mr. Galt is just diminishing because of his actions, his conducts. It's not something that I've done or I've not done for him. You know, I've got kites from Mr. Call that he indicates he doesn't have discovery. He's got 2 sets of discoveries, 10,000 pages or so of copies that have been made and provided to him. So when he says he doesn't have those, they're untrue. And I just can't do these things and then get into a position where I have to deal with grievances and malpractice suits when those are again frivolous, that he's claiming that he's filed and he's done those things. So I've reached a point where there's a breakdown. I will admit to the court, the only things that Mr. God does not have is the search warrant body cams, because I got them this morning from Mr. Ziegler. They're in my pocket. And again, certainly my intent is to download them to my office drive, so I have a copy. There's a laptop at the jail, and then Mr. God will have a copy to watch those there. So that's the only thing that he doesn't have, but he doesn't have those because we didn't have them until this morning when Mr. Ziegler handed them to me in court. Outside of that, I've had numerous emails with Mr. Ziegler, numerous phone calls. We've talked about a lot of other issues, litigating issues. At one point, Mr. Galt wanted me to set up some interview with the FBI, and in fact, made threats because I was not doing that, made threats towards me for not setting up the interview. And again, I indicated to Mr. Galt, I need to know what you're going to tell the FBI because you have certain rights. If you're going to incriminate yourself, I have to advise you and warn you of those rights. He wouldn't tell me. We did set up the interview. The interview was recorded. And again, Mr. Galt, that interview never went anywhere because Mr. Galt got angry and upset because it was being recorded. The FBI agent did Mirandize Mr. Galt, and that's not how Mr. Galt wanted to operate. So all of the things that Mr. Galt has done has, at least for me as an attorney at this point, led to a breakdown where I can't communicate with him. I can't represent his interest, and I refuse to go forward with this case and assist Mr. Galt any further because of what he's done with his verbal abuse, his threats, his derogatory attitude towards me, and I'm just refusing to put up with that, Judge.
All right, guys, this is the turning point where the judge says the quiet part out loud. The court explains, point blank, that no matter how many attorneys are appointed, the same problem will repeat itself. Why? Because the defendant refuses to accept professional judgment unless it matches his own. This isn't about bad lawyering anymore, it's about control. Once a judge identifies a pattern of behavior, the case shifts from problem solving to damage control, and the defendant is now fighting the record, not just the charges.
All right, Mr. Ziegler, do people take any position?
Your Honor, normally I would leave this kind of thing to the court and to the attorneys, but in this case, this is a case that has been going on for quite some time. Obviously, it's a very serious case. It's a case I would like to get to trial as quickly as possible. I agree with the court's concerns regarding Mr. Galt's behavior. I think it doesn't matter how many attorneys you appoint, and that's evident from the fact that Mr. Seeger had to withdraw, and Mr. Galt grieved him. Now Mr. Gurmurthy is asking to withdraw, and apparently Mr. Galt is grieving him. I have no doubt that if you appoint a new attorney to represent Mr. Galt, that attorney will ask to withdraw. Mr. Galt will grieve him, and we can play this game for however long as Mr. Galt wants to play it, or however long as the court wants to entertain it. But at the end of the day, we're going to have a trial on this case. There's no likelihood of any sort of plea resolution. We have a trial set in May. I would prefer to have that trial as opposed to appoint a new attorney, kick the case out 6 months, and then come back here in 6 months on probably similar issues where that attorney is not going to want to file the frivolous motions. And Mr. Galt wants that attorney to file. So for those reasons, Your Honor, I don't think the court has to permit Mr. Gurmurthy to withdraw. I'm certainly sympathetic to Mr. Gurmurthy's position here today. I think he had to do what he had to do. He had to file this motion. He had to make his conflicts known to the court. I certainly wouldn't want to be in his position today, Your Honor, but from my perspective, I have a duty to the victims to bring this case to a trial and to a resolution as quickly as possible, and I would oppose any further delays.
Mr. Galt, anything else that you want?
Your Honor, I've never verbally abused Mr. Gurmurthy.
All right, guys, this section is devastating because it's calm, detailed, and methodical. Administrators and defense counsel lay out the timeline, correcting the defendant point by point. Motions were filed. Transcripts were provided. Discovery was delivered. And then comes the real blow: allegations of verbal abuse, threats, and grievance filings used as leverage. This isn't emotional testimony, it's procedural cleanup. And once multiple professionals independently tell the same story, credibility shifts hard. At this point, the courtroom doesn't see a victim of the system, it sees a recurring problem.
No, we've had conflicts. Yes, we have. We've argued. Yes, we have. But the things that I've asked Mr. Guramuthi to file motions on are legitimate things. The fact that I never even got a copy of the motions that he filed is legitimate. You know, Your Honor, you're the one that told him, this is unacceptable. You didn't show up to court. This is unacceptable. You did not file your motions on time. That was 14 months. Mr. Seeger killed 5 months before he was willing to withdraw because of the conflict issue. I didn't grieve Mr. Seeger for another 6 months after that. So it's not why, the grievance is not why it got handed over to Mr. Thompson. The grievance didn't come for months, 6 months after Mr. Guramuthi was assigned the case. Okay, I mean, I got a search warrant right here that was never signed by a prosecuting official, by a non-attorney magistrate. You know, Mr. Guramuthi fails to be willing to file a motion on these things. Your Honor, you said in court last time we were here that you're not going to have this come back on an appeal. Your own words, Your Honor. So these things are things that are going to make this come back on an appeal. Mr. Guramuthi just got a copy of the body cam footage of the search today. 18 months, Your Honor. And he just got it today. I've been requesting it the whole time. I've been requesting officer activity logs the whole time pertaining to the deactivation of body cam footage. I've researched case laws. I mean, all these things are legitimate motions that should be filed, Your Honor, and you, Your Honor, get to rule on them whether they're frivolous or not. That is your job. These are legitimate things that counsel should be filing motions on as a defense counsel. He works for the state. You know he works for the state. He don't work for me. You know, he's told me several times, I got funding for this, I got funding for that, I got funding for the transcript. I contacted Nicole Hagstrom, the transcriber. She said, I contacted Mr. Guramuthi. He said he'd do what he has to do on his end. We'll get you them transcripts. Nothing. I got a paper right here signed from Mr. Paul Stout. Said that appointment of substitution of counsel is warranted only by showing of good cause. Good cause may exist when a legitimate difference.
I understand that. I don't need you to read that to me. I know what the standard is.
And it stands right here, Paul Stout. Mr. Guramuthi's filed a motion, said there's been a breakdown in the client, destruction of communication, and breakdown in the current attorney-client relationship. I filed several motions. There's been a breakdown in attorney-client relationship beyond repair. Beyond repair. If you send me to trial with Mr. Guramuthi, Your Honor, that's automatic grounds for an appeal. You said yourself, you don't want this case to come back on an appeal, and I'm quoting your words over and over again. If you don't want it to come back on an appeal, sign me a counsel that's going to file these legitimate motions.
Okay. All right. You're just starting to say the same things over and over again.
You know, I'm not trying to waste the court's time. I just want proper representation.
Okay. I understand.
And then I'm sorry, in the typo, Mr. Thompson says typo. Your Honor, this is a murder case. There should be not typos. The T should be crossed, the I should be dotted. There should not be wrong dates, wrong addresses. None of it. This is a murder case, Mr. Ziegler. It's a murder case. This stuff should all be checked and double checked and triple checked and quadruple checked before it is even filed.
All right, guys, now the prosecutor steps in and closes the escape routes. He makes it clear this case has dragged on long enough and that replacing counsel would only reset the same cycle. The argument is simple and effective: delay doesn't equal justice. The prosecution isn't emotional here, it's practical. Trials must happen, victims deserve closure, and the court can't let one defendant stall proceedings indefinitely. This moment reinforces that the system's patience isn't infinite, especially when the tactics are transparent.
The notice right here, let me show you this, Your Honor, before we end this. Right here, Mr. Guramuthi's withdrawal is dated December 9th. December 9th, dating a, where is it? I got it right here, Your Honor. I'll pull it out of this one. The notice for hearing for today, dated December 9th, 2024, for an April 8th, 2025 court date. That's 4 months ago. This paper right here is grounds for an appeal. You know, Mr. Seeger, 150 days. Here's another 4 months. Mr. Guramuthi didn't represent me. That's 9 months out of the 18, Your Honor. My 180-day rule was violated. My right to a speedy trial was violated just because of these issues. Mr. Ziegler in his motions are quoting COVID-19 case laws for violating my 180-day rule and my right to a speedy trial. You read the motions, Your Honor. I've actually got them right here if you want to go through them again. His motions are quoting COVID-19 case laws for violating my 180-day rule and my right to a speedy trial. There's grounds for appeal. Any case is prolonged for more than 18 months. The people's got to answer for it. By the time I go to court in May, it's going to be 19 months. That's automatic grounds for an appeal. The people are going to have to answer why I wasn't in trial before 18 months.
Okay.
You know what I mean? I'm trying to save the court's time, Your Honor. I just want
I
proper
appreciate that.
representation.
All right, guys, this is the defendant's last stand, and it sounds exactly like every desperate argument before it: long, repetitive, and increasingly frantic. Speedy trial claims, COVID references, body cams, appeal threats, it's all thrown at the wall again. But the tone has changed. The judge isn't debating anymore, he's managing. When arguments start looping without adding substance, courts stop engaging and start concluding. This segment feels long on purpose, because that's exactly how it felt in the room: exhausting, circular, and ineffective.
Yeah, okay, all right. First of all, with regard to allowing counsel to withdraw or appointing new counsel, it matters within the discretion of the court. I'm acting within my discretion in ruling on this. First thing I would say, Mr. Galt, is you're free to hire your own attorney at any time that you want. Nobody's forcing you to have court-appointed counsel. So you're free to hire your own attorney. To the extent that you're asking the court to appoint counsel at public expense, there's a process for that. And that process has been followed. And it's resulted in Mr. Gurmurthy being appointed as your attorney. The fact that you filed grievances against him or other attorneys isn't a reason for the court to appoint new counsel. It's not a reason for the court to allow counsel to withdraw. That's been through case law clearly established that defendants are not allowed to delay cases or shop for new attorneys by filing grievances in the hopes of having that attorney disqualified or somehow being required to withdraw. So the grievances aren't a reason. MIDC has addressed your request for new counsel. Under the law, it's clear that the court is to be minimally involved, if at all, in that process. This is the last step, which is the only reason why it's before me, but it's clear that the legislature has determined that the best process is for the court not to be involved, because the court's supposed to be impartial and it shouldn't be involved in issues relating to your counsel. So this is only here as a last resort, but MIDC has followed their policy and procedures, and they've denied you from receiving new counsel. So the MIDC, through two different administrators, have determined that there isn't good cause for you to be appointed new counsel. I have concerns, as I articulated before, and listening to you, it just reinforces those concerns that it doesn't matter who's appointed to you as your counsel. I'm convinced that you're undertaking a course of conduct here to create appealable issues on your own, and you've admitted it. You're on the record. You told me that you purposely didn't say anything about paperwork that you received and let counsel go forward in the hopes that that's going to create an appealable issue. So I think you're actively, and I want the record to reflect that I think you're actively trying to do things here as part of the pretrial process in hopes of creating appealable issues, so that if you are eventually convicted, you'll have a basis to come back. And I think that's important, because to the extent that I would find good cause to appoint you different counsel or to have Mr. Gurmurthy withdraw, I think you continue along the same course of conduct with the new attorney. Not only to delay as long as you could in the hopes of getting to the 180-day issue, or whatever you perceive to be as issues that could result in a reversal of your conviction later, including delay, including complaining about your counsel, including doing things in your interactions with your counsel. All of that, I'm convinced, is a deliberate course of conduct on your part, aimed at creating appealable issues. And I'm not going to allow you to just continue to do that over and over. I think there is not cause here to appoint new counsel because, again, I think the same issue would simply come up over and over again. We did have hearings on the motions that Mr. Gurmurthy felt had legal merit. I agreed that they had legal merit, and I made rulings on those issues, a lot of which involved issues that you're raising here today about affidavits and signatures and those types of things that the court has addressed.
But how
And
about,
not every mistake, not every typo means that the court has to throw out an entire case against you. So the fact that there are errors, there are minute typographical errors in every case, I would argue. But that doesn't mean that you're just entitled to dismissal of charges because an I didn't get dotted or a T didn't get crossed. So to the extent that you think that's an appealable issue or a reason for your counsel to file a motion to dismiss murder charges against you, which are very serious, I just think you're wrong about that.
I'm not saying that.